morning to our special guest, Professor Bruce Edwards. How are you doing, Bruce?
I'm doing well. Thank you so much for allowing me to join you today.
I am sorry to make you wake up so early in California.
It's all good.
Thank you, Bruce. Please let me make a short introduction in Portuguese and then I come back to you, okay? Além do conferencista Bruce Edwards, compõe a mesa virtual de abertura desse evento os meus colegas e amigos, todos eles entusiastas da resolução adequada.
Bruce Edwards, but we also have other people coming to enlighten this event today. We have Dr. Judge Aramis. He's the Vice Director of the Judicial School here of Paraná and the coordinator of this Judicial School of the 9th Region. We have Flávia Falcão. She's the Director of the Judicial School of the 9th Region too. She's the President of the College of all Judicial Schools in Brazil. And Judge Dorotea Mota from, she comes from Bahia. She's a professor of law too, and she's a professor of mediation. Aramis, Flávia, Dorotea, and so they are all experts in the area of mediation of this 9th Region Judicial School. And I think the presence of everybody here, especially the presence of Bruce. So Bruce, I'm going to speak, to give the floor to Dr. Aramis. So Dr. Aramis, please. Good morning, ladies and gentlemen. Thank you, Fernando, for receiving me here. On behalf of the 9th Region, I'd like to thank Professor Bruce Edwards to accept our invitation to take part on this event and share his knowledge with us, with judges, lawyers, and civil servants, public servants here. So I'd like to greet Judge Flávia Falcão, Judge Dorotea, and all the attendees, desiring a very fruitful morning for all of us, full of knowledge. Thank you, Judge Aramis. So now the floor is yours, Judge Flávia. Oh, sorry, I was silent. Good morning, everybody. Aramis, Dorotea, Fernando, and special greetings to our speaker of the day today, Dr. Bruce, Professor Bruce Edwards. It's such an honor for me to be here in this event with somebody who is a reference in mediation and the culture of peace. Along this past years, we've been having so many nice, great classes on the subject of mediation, and your presentation is the cherry of the cake. So yeah, it's important to really change the culture. We know that changing is not an easy task, but I believe that we've been advancing in this field, and your presence here today, we have so many attendees really looking forward to your speech. I believe that the Brazilian judicial system really supports this methods of mediation and disputes, and we recognize, we acknowledge this. But I'd like to say, I want to be brief, but I'd like to publicly thank the partnership that we have between the Judicial School 10th and 9th that was developed from Judge Morgana and Judge Cássio, and now Judge Arnaud and Judge Fernando. Fernando is such a dedicated judge. He's not only a colleague, he's a partner, he's an admirable person, and he's my personal friend. Fernando, congratulations to the development of this work. You've been doing a great job, not only at the 9th school, but also EMATE. E-Judge 9th made a difference contributed so much for the training and forming of labor law and all the changes here in Paraná and in Brazil. So thank you so much. Judicial School 9, in which Fernando is the president. So I'm sure that everybody agrees. So let me stop talking, because otherwise I'm going to be too long. I mean, then, you know, we're here to hear you, not to hear myself. Thank you. Thank you, Flavia. Thank you for your great words. Thanks. I'm very thankful for you. I'd like to really thank from the bottom of my heart. And Dorothea, the floor is yours. Thank you, Fernando. Thank you, my dear friends. Good morning, speaker, Professor Bruce Edwards. Thanks, Aramis and Flavia. And also my friend, Fernando Hoffman. He's like a brother to me. So, I mean, to hear Bruce Edwards is such an honor that makes me really glad. He's a leader, he's a reference in the mediation field for over 30 years, right? And certainly he has a lot to teach us, to share with us. I am a labor judge. I am an alumni of Pepperdine. I am a judicial mediator myself. It's such an honor for me to have the opportunity of receiving you, Professor Bruce Edwards. And thanks for Judge 9 for inviting me, Judge Aramis, Judge Flavia, and my dear, dear friend, Fernando Hoffman. So I'm here willing to just participate in here. So thank you so much for having me here. Thank you so much, Dorothea. Thanks, everybody. I'd like to thank the audience. I mean, we have a lot of people already, you know, and I am sure that we're going to have great questions. Guys, you can ask using the chat, because in the end, Professor Bruce Edwards is going to be answering some of these questions. So Bruce Edwards is a mediator and one of the partners of GEMS, one of the biggest mediation companies in the United States. He has been the president. He is the president of the council. He's a professional mediator since 1985, considered one of the pioneers in mediation. Mediation is such a tool for commercial disputes in the United States. He has mediated more than 7,000 cases and very complex and difficult disputes, very emotional ones. And Bruce has dedicates a lot of time in sharing his practical knowledge since 1995. He's been teaching advanced mediation in many institutes, in Pepperdine University, and also more recently, not only training hundreds of aspiring mediators in Europe, Asia, South America, and Africa. Bruce has been working with government leaders and international institutions to find means in implementing the mediation in this system. So I'd like to introduce now Bruce in English. So
Bruce, thank you once again for having accepted our invitation. I'm so grateful. The reason why we have invited you to this conference lies not only in your wide knowledge and experience, but also in the fact that you are a professional who inspires and encourages students and professionals to always learn more about mediation. Here in Brazil, mediation and other ADR means are growing more and more. Negotiation and mediation are improving in employment and labor disputes and cases, and mediation is finding its place besides conciliation in the labor justice. By the way, in a recent poll with plaintiffs, defendants, attorneys, and others, 95% of the participants pointed out that labor courts must continue to invest in a mediation policy. Employment judges have been required to attend long-term mediation programs. Here, in the Ninth Circuit Labor Court, we are close to end a 100-hour mediation program with more than 150 judges and public servants. And today, you, Bruce, our guest, is here to approach impasse in mediation. The impasse is a critical issue in mediation. In my point of view, the ability to overcome impasse is one of the most critical skills. Perhaps it's the skill that distinguishes the good mediators from the excellent mediators. And nothing better than have an excellent mediator and professor such as you to help with this subject. Thank you again. You are welcome to Brazil.
Thank you so much, Fernando, for the kind introduction and the invitation to join you today. Thank you to the distinguished judges who are obviously providing the leadership within the labor courts and beyond in Brazil. Culture of mediation changes often from the top, and it's great to have you with us today to demonstrate that type of leadership. Let me begin with an apology for not being able to address you in your native language. The good news as I travel the world is that the language of conflict is universal, and therefore so many of the lessons of conflict resolution are also cross cultures and cross language divides. My hope today is that I can be clear in my communication, but obviously I will leave plenty of time for questions to follow up on comments and things that perhaps are unclear. Don't hesitate to ask questions when the time arises, and please make sure you take away from today as much as you can. I'll do my best in the next 40 minutes or so to live up to the kind introductions. I'd like to start by just giving you a brief picture of my journey in the mediation world, so you know from where I come. I went to college and studied psychology, thinking that I wanted to go to law school, but at the time having no idea just how important those lessons would be in my future career. Someone asked me once, a newspaper writer, when I was visiting India teaching mediators, how I had sort of chosen this career path. And I thought about it for a moment and I responded, you know, sometimes in life, I think the better wisdom is to determine that life chooses you and moves you along a career path. And I didn't know it at the time, but my background in psychology was preparing me for a career as yet unknown. I started as a lawyer in the first 5 years or so of my practice, but quickly realized that many of my clients were not particularly well served by our traditional system of justice. And I quickly started thinking about why. And I applied many of the lessons of psychology in my early thought process, and particularly noted that clients were not as involved in the dispute resolution and the conflict resolution as we were as lawyers. They were often left out of the process. And so when I would take clients to the courthouse, I would go into the judge's chambers to talk about resolution. And my clients would sit out in the hallways on hard wooden benches and not be part of the process until I would come outside and explain to them what the judge had informed me was in their best interest. And I still to this day remember the sort of disappointing looks on their face from not being part of that process. And so over time, I started looking around at different kinds of processes, and to keep a long story short, started to experiment with this process that later became known as mediation. And not too long thereafter, I left the practice of law, much to the surprise of my parents, who thought I was walking away from a good paying job and a good career to enter something that no one had ever heard of before, much less succeeded in. And I was one of the early pioneers, one of the first to develop a business of mediation in the commercial sector in the United States. And as was so kindly said a few moments ago, we have since developed that early business into the largest provider of commercial mediation services in the United States, a company called JAMS. I've served as the chairman of the board, and I've certainly served in a variety of capacities as we've grown that company into 26 states around the country. And we currently mediate over 15,000 complex cases each year, ranging from all sorts of commercial disputes involving banks, businesses, intellectual property, insurance, employment, environment, construction, and I could go on. But all of those kinds of cases that find themselves into our commercial courts are certainly candidates for mediation within our company. And most of those categories of cases I have mediated in the last 35 years. I was once introduced by a colleague of mine in Austria to a German audience. He had calculated that based on my experience in mediation, I had spent somewhere between 50,000 and 60,000 hours mediating. And most of my days still are spent in 7, 8, 9 hour days of mediating disputes. And so it's with that sort of background and experience that I like to share with people a lot of what I've learned, in hopes that it jumpstarts and assists your culture and your development of mediation. I know today the audience is primarily focused on labor issues, and I've had the privilege of mediating all sorts of cases involving labor, from sexual harassment cases, hostile work environment cases, wrongful termination cases, wage and hour disputes, and recently mediated several class action lawsuits brought by drivers of Lyft and Uber seeking better wages and treatment in various cities in the United States. So I'll talk about some of those experiences as we move on. But as Fernando and others have said, along this career path, I've also developed a fondness for teaching and sharing what we've learned both within our own company and within the United States. And we've, with my wife, about 8 years ago, we developed an online training platform called Edwards Mediation Academy. Little did we know in the pre-pandemic world that we would be developing a pipeline of sharing and information in a virtual world that would be so well suited once we all found ourselves in a COVID environment. But more to the point, I've now taught mediation in over 20 countries face-to-face. I'm off to Dubai, I think, next month to do some work in the Middle East. I've been to India. I've had the real pleasure of coming to Rio de Janeiro on 2 occasions to help share thoughts and lessons on issues like apology and forgiveness, on mediation culture, and other topics of interest. And I'll say that through my friends in Brazil, I've really been pleased to see how far along the path you all are in Brazil in developing a culture of mediation. And I look forward to these and enjoy these opportunities to share lessons and thoughts about our various experiences and developing cultures. It's just an honor to be here and to have this opportunity. I speak so much first about the value of training and education because I often tell people, and I often begin conversations by saying, in mediation, as in life, one of the real dangers is not knowing what we don't know, not knowing what we don't know. And I say that because, at least in my experience in the United States, so many people have found their way into the world of mediation from a legal background. And because of that background, think that they have the knowledge necessary to be effective mediators. And in part, that's true. There is value to bringing one's judicial background, experience, their legal knowledge, their knowledge of the process to the mediation table, absolutely. But I also tell people that lawyers and retired judges have not a monopoly on the skills that are required to be effective in mediation. And over the years at Pepperdine, where I've trained mediators for over 25 years, and other institutions, I have had the pleasure of training religious leaders and therapeutic scientists and politicians and others who come from a rich diversity of backgrounds, but with an open mind to developing the skills required to be an effective mediator. One of the things that excites me about my conversations with my colleagues in Brazil is the commitment to education and training. And so many of you, not just by your presence here today, but by your travels to Pepperdine and your commitment to learning generally, the laws you have established that allow for mentoring and practical experience in addition to classroom education, it all demonstrates a commitment to mediation and learning. And I'm fond of telling people that as mediators, learning is a lifelong journey. There isn't a day that goes by that I don't learn something more about human behavior or learn something more about mediation based on the people who are in front of me and the experiences that I have. All of this commitment to education and training that you are demonstrating today is both essential to your individual success in the mediation profession, as well as implementing a successful mediation culture. Because at the end of the day, what we're trying to do is to create successful, satisfying experiences for those who go through the mediation process. I often teach students to think in terms of what we call a satisfaction triangle. And by definition, a triangle has 3 equal sides, of course. And I often write on the whiteboard what those 3 sides represent. One is the party's outcome satisfaction in the mediation process. That's the most obvious. That is the question of how satisfied are participants that they achieve their desired result in the mediation process. Another co-equal side of the satisfaction triangle, though, is process satisfaction. How were people treated in the process? Did they feel it was fair? Was it organized and designed in a way that met their needs? And finally, importantly, the last leg of the triangle is psychological satisfaction. And this gets to the heart of what we do. This is the question of whether or not people's psychological needs were met in this process. And I'll pause for just a moment, and I promise you I'm getting to the topic of the day, impasse, but I do think it's important to set the stage. And while we travel to different parts of the world and talk with people about mediation as though there were one type of mediation and one definition, I think it's important to, at least from my perspective, understand how I define the term. When we were, and I don't take credit for it personally, but as a group of leaders in the field in the United States, at least my impetus in mediation and developing the process resulted in a process that I define as follows. First and foremost, it's an interest-based process. The goal is to define what the interests of the participants are, to know from a human standpoint what gave rise to the dispute, and hopefully therein find a key or an answer to what it will take to resolve that conflict. The second component of the process, as I define it, is the right of self-determination. This goes back to the story I was sharing about my client's dissatisfaction with not being involved in disputes and how to resolve them. And so in mediation, we advance participants really to the front of the table so that they can both understand the nature of conflict and participate directly in its resolution. And finally, and this could, Fernando, be the topic of a different day's conversation, but what is the value of emotion and the human content of conflict? Because so often in our court system, at least in my early days as a young lawyer, we were so limited in our focus on the facts and law that we left out the human element of the conflict. And particularly, we didn't understand in those early days the important role of emotion in conflict. And now through neurobiology and other magnetic resonance imaging, studies of the human brain, we know, for example, that there is no cognitive thought without an attached emotion. And that's why when you think back on your early childhood memories, you think from a cognitive standpoint, they're usually attached to strong emotions. And that's what helps us code memories, retrieve them, and it ultimately is the core of our human interaction. So it's a fallacy to think that we can somehow deal with conflict without also simultaneously attending to the emotional component. So those are some of the key elements of the mediation process as I view it. Obviously, everyone is entitled to their own perspective, but as I proceed with my comments, I think it will become even more clear why that becomes my focus. Okay. I'd like to distinguish between different kinds of mediation models for just a moment as I proceed to a discussion of impasse. Everyone is familiar with different kinds of mediation. This group is very experienced. I'm not sharing anything new. I'm simply commenting on the different approaches. And in the early days, I think in the United States, we had mediation in the community context. We had mediation in the family context. And I like to think that my contribution to the field was simply to take many of those lessons and try and apply them for the first time in the context of commercial disputes. Now, as in most countries, there is court-annexed mediation processes. And that is something that is a very favorable development, because in many countries, the judicial system stands apart from other branches of government in terms of respect by constituents. And when people see mediation being promoted by the judiciary, when they participate in that process, it has the imprimatur of government, and along with it, advantage in terms of implementing mediation system-wide and society-wide. So it's a wonderful thing. It is a different process in itself. And typically, in traveling around the world, what I find is court-annexed mediation processes typically are mediated by judges like yourself. Typically, those processes are done at the courthouse. Typically, those processes have limited time because judges, by definition, are so busy and have so many cases. And all of that sort of structure has both advantages and disadvantages. There's no right way or wrong way to mediate necessarily. There's just an understanding of what the advantages and disadvantages are as one contemplates the design of a mediation process. I'd like to contrast that with the type of commercial mediation practice that I have helped develop in the United States and within our company in particular. Most of the mediations that I'm involved with, we have the luxury of time. We have the luxury of a full day of mediation. Many of the complex cases that I'm involved with start one day and continue on subsequent days, sometimes spread out over weeks or months, sometimes involve dozens of parties and disputants. And really, the benefit of the commercial mediation approach is it allows us really the flexibility of time and the opportunity to apply resources to a particular dispute. We also have the luxury of good office space where we bring food in and people can separate over distance and spread out and really feel comfortable in the environment that they're in. Of course, the last 18 months for everybody has been a traumatic episode in our collective lives. And in the world of mediation, literally overnight, I shifted from in-person mediation to mediating online using a Zoom platform. I was in the middle of a 2-day case involving 20 parties when my office manager came in and said that the mayor of San Francisco has concluded we are a non-essential business and we're closing down tonight because of COVID. And so I went home and I got on YouTube and I started familiarizing myself with the Zoom platform and counseled everybody to join us the next day. And since then, almost every day, I've been mediating on a Zoom platform. So my point in all of this is simply to say, recognize that there are different approaches to the mediation process. There are structural strengths and weaknesses depending on the process you design, the process that you implement, and be attentive to that. I know at times from a judicial standpoint and a court-annexed standpoint, there are limitations to what opportunities and what design you can implement. But expand your thinking, be creative, open your mind, and think about, as we talk today about different ideas, what this process can look like as it evolves, because we are all still together in this grand experiment of helping define our profession and define the best approach to dispute resolution. Let's talk for a moment as we move toward impasse about what I describe as the mediator's mind. And before we get into any skill set, we always, as individuals, bring to the table a philosophical approach, a psychological construct, a sort of a mental image of how we're going to interact with participants. However we describe it, I put it under the umbrella term of a mediator's mind. And whatever mindset we develop, we have to be aware that is going to shape each of our various interventions in that dispute. I'll give you a couple classic examples. And again, none is necessarily right or wrong. They're just different. In the United States, we have court-annexed mediators trained by court programs on a panel of mediators to be selected from by participants, usually volunteer in the first instance. And as I've said already, structurally, those mediators come to the courthouse. They're often handed a file and given 2 hours or so to assist the participants. And largely, their success or failure is measured by one criteria. Can they hand a file back to the court clerk saying this is a concluded dispute? Is this a closed file? And so their mindset, their mediator's mindset is, how do I get from beginning to end in a short time frame? How do I get to closure? Contrast that perhaps in a world of commercial mediation, where some parties might, or some mediators would come in to an employment dispute. Maybe it's a wrongful termination case, and their mindset is perhaps, yes, can we get a deal done? But along the way, can we clear up miscommunication? Is there a way to potentially restore relationships? I'm open-minded to some transformative practices and just maybe a broader perspective that I bring to the table. Again, neither is right or wrong. It's simply to help educate you, or at least sensitize you to the idea that we all bring this mental model to the table, and it impacts us at each step of the dispute resolution process. Let's talk now, I think, for a moment about impasse, because that was your kind invitation for me to join you today. I'm reminded of a 19th century, I think, German philosopher, and I was taught this because most summers for years I was privileged to teach in a mediation camp with a psychotherapist in Austria, where we taught to German-speaking mediators the process of mediation. And so I heard about this philosopher, and his quote that I remembered so vividly was, "The limits of my words are the limits of my world. The limits of my words are the limits of my world." And it really suggests that we are so impacted by the words that we use to experience the world around us. And why is that important? Well, let's start with the reason we're here today, to talk about impasse. Impasse itself is a word that sort of connotes intractability. I have to look to see the actual quote because I looked it up in preparation for today's comments. And it's defined as a situation in which no progress is possible. Impasse means a situation in which no impasse is possible. Well, how sort of dark a moment does that present as mediators? And instead, I encourage people to think about impasse differently from the beginning. This is part of your mental model. I think about impasse not as some intractable moment in dispute resolution, but rather as and something that is to be anticipated, if not ultimately welcomed. Because when you think about it, people in conflict, they have their own narrative, human nature. They have their own view of the conflict. They tend to share that one-dimensional narrative with their counsel as they prepare for and come into a mediation environment. Typically, they have had a conversation about how far they may be willing to move in the negotiation. And almost the mirror image is happening down the hall or down the street with the other side. They have their perception, they have their narrative. They've shared that narrative with their counsel. And only the best counsel are really able to sort of see beyond their client's individual view. So when they come also to the mediation table, they have a pre-mediation plan and how far they're willing to stretch. And almost by definition, those positions are not prepared to overlap. I know that as a mediator. And so that means that when parties get to the edge of a precipice, looking across at each other in negotiation, to me, it means they've reached the end of their pre-mediation narrative. And now the real work begins. Now we have to exhibit the patience and the creativity and the persistence to try and help these people move beyond those pre-mediation positions. And so I think about it like a weary climber trying to reach the summit. There are those plateaus along the way to reaching that summit where people really need to pause and acclimate both to the height that they've achieved. Where it's appropriate as mediators, we acknowledge and compliment the effort it's taken to get to that plateau. At the same time, we challenge them to move on, and we're there to assist them in that final journey, which oftentimes is a journey they haven't contemplated before they came to mediation. That's my mindset. That's my mental image. And that's what allows me, when we reach impasse, to be of a mindset that is both welcoming and encouraging, as opposed to pessimistic and discouraged. I think it's important to note that while we talk about impasse and think about it as something that occurs at the end of the mediation, and absolutely that's the quintessential opportunity for impasse to rear its head, impasse can occur at any moment. There are those mediations where impasse occurs at the very outset. I'm reminded of a case I had recently. It was scheduled for a 2-day mediation. It was not a labor case. It was a case involving the largest public utility in California and the city of San Francisco. Large contingents on both sides, and they arrived at my office only to find out within the first minutes of mediation that one of the sides had not brought to the mediation the high-level decision makers that were represented on the other side's team. And so important was that in the process that it took me 7 hours of mediating between those sides at different ends of the hallway just to get them to agree to finally come into the same room together and begin the process. There was a classic moment of impasse that almost started before we left the starting gate. And so be aware that impasse can occur at any moment in the process. One of the reasons that impasse occurs is because we hurry through the process. And I've tried to give some thought to this as I talked with Fernando last week, and I thought about this audience because I know by structure and by definition, you have limited time to devote to the process. It's different than the world I live in typically. And yet, I think it's still important to comment on this topic. One of my favorite words in teaching mediation is deceleration. Deceleration. I hope that has a good word in Portuguese that translates well, because it is so important to what we do to slow the process down. So many of us, and I'll be the first to acknowledge it, so many of us are in the mediation world come from a background of what we call in English a type A personality, being driven, being used to succeeding, being used to directing traffic, if you will. And we bring that experience to the mediation process. Yet it is so important in mediation to attend to the process itself, meaning the importance of listening to people, the importance of trying to find the ability to connect with them, and ultimately, those are critical and essential to persuading them in the mediation process. And what I find, and this is a key point, what I find that is often the first casualty of an accelerated process is our opportunity and ability to be an empathetic listener and to connect with people. And it's unfortunate because it short circuits the value underlying the mediation process. Again, going back to my mediation journey that I've experienced, one of the key lessons that I stumbled on so many years ago is that this mediation process allows us to help people move through conflict, yes, in an expedited way, but expedited compared to a traditional litigation process. There are limits still on how expedited we can bring people along that path. And it's critical that whatever the process you choose to employ, whatever structure you are allowed to operate in, acknowledges the human element in that dispute and allows for the opportunity to listen to people and connect. And that really is the key that often unlocks the door to conflict resolution. So think about that from the standpoint of what you're trying to achieve. Let's talk about impasse, though, in its more traditional setting, and that is late stage negotiation, where parties reach a seemingly intractable position. And what then are the tricks, if you will, to try and resolve that impasse? I tend to avoid using the word tricks. I prefer tools, because in English, at least, tools connotes the necessity for knowing how and when to use an implement or an instrument to its full advantage. There is nothing tricky about what we do. There is only hard work combined with knowledge and skill. And so those techniques or tools that we use require knowledge of their application and a keen knowledge of when to make use of that tool itself. What are some of those tools? Well, again, it all starts with patience and understanding for the moment you're in. It starts by acknowledging that people are in that moment of impasse, largely because they have reached the end of their pre-mediation objective and they're still not seeing settlement as possible. So as mediators, one of the key techniques for trying to overcome that moment is both to respect and acknowledge the effort that's gone into that party getting to where they are in the moment, and being a cheerleader for ongoing effort, to be perhaps the only person in the room who can help talk to people about having been in this position before, and with acknowledging that with some additional patience and hard work, it's still possible to crest the hill to get to the settlement objective. What are some of those specific tools or techniques that assist the mediator in that moment, aside from just a mental model that appreciates how far the parties have come, expressing appreciation for their hard work, and really helping to prepare them for the last steps that are required? Well, there are those techniques that you've undoubtedly heard of and many of you use in your own practice. Certainly, one of them is a mediator's proposal. A mediator's proposal is a technique that often allows us as mediators to take some of the back and forth out of the negotiation at that late, most difficult stage by saying to the parties, what I'd like to do is offer a suggestion to both sides simultaneously. And I can either do it verbally here in the moment, or after today, I can send you a written statement that includes my suggestion. But it's important you understand this is not me putting on now some arbitrator's hat or judicial hat and saying, this is what I think the case is worth. It's me as a mediator, having listened to both sides all day, find perhaps the last potential common ground and put that in front of the parties and give you an opportunity to say yes or no. And if everyone says yes, we have a deal. If any party says no, and we will respect your right to say no, of course, there's no deal. You're on the path that you're on, and you will continue through litigation. But it is a technique that I use maybe 2 or 3 or 4% of the time as a last step, a technique when the parties are exhausted, seemingly without the ability to move forward themselves. And it gives us one opportunity to seize the moment and potentially capture success. I also find it very helpful in those situations where there are governmental entities. I had a case this past week where involving a city council, and they had their city attorney at the mediation. And at the end of the day, he was very close to, but not able to get to a settlement. And I suggested a mediator's proposal that he could then take back to the city council for approvals. And he was able to go back and say, this is what the mediator has suggested. We weren't quite able to get there ourselves, but here is the mediator's suggestion. And the city council approved the suggestion, and we were able to settle the case. So that's one technique. Another classic technique is a conditional offer or a conditional movement. Sometimes people describe this process as bracketing, and it's as simple as saying to one side, you all seem a bit unable to move forward. How about I suggest the following? Will you move to this position if I can get the other side to respond by moving to this other position? And therein, letting people see that some additional progress can be made through a conditional step or some kind of a bracketing process. I often use what I describe as counterintuitive moves as an impasse breaking tool. A classic one is it's intuitive for us as mediators to feel like we always need to be talking, to feel like we always need to be directing traffic, to the point where the participants in the dispute look to us to sort of continue the conversation. So what if in those difficult moments of impasse, you simply say to the parties, you know, I look to you for guidance now because I don't have any ideas. And you sit back and you are quiet. I guarantee you there will be no more uncomfortable seconds or minutes that follow than you sitting there not saying anything, but looking from one party to the other, waiting for them to seize the moment and try and recreate progress. To me, that's a counterintuitive technique for trying to get people to continue moving through the impasse moment. Oftentimes, as we know, we structure mediation in different ways. We often in the United States, in the commercial world, use a combination of joint sessions and private breakout rooms. And many lawyers in the United States, particularly in labor cases, particularly in cases that involve sensitive topics like sexual abuse, or sexual harassment, even wrongful termination environments, hostile work environments, they choose to separate the parties. And this is a whole different discussion and a pet peeve of mine as we seek to train lawyers how to better navigate the process with their clients. But to this day, there are still many lawyers who opt for or default to a private session model. And so one of the techniques for overcoming impasse, I find, is if that process has stalled out, to suggest a change in the process itself. And I'm reminded of a sexual harassment case several years ago where the lawyers had decided to do just that, to opt for private breakout rooms all day long. And along the way, the woman who had been harassed by her male supervisor said, Bruce, why are we in these separate rooms? I want to talk to the other side. And I looked at her lawyer, I said, I can do that very easily and would actually appreciate the opportunity. And so I did create that moment. I brought them down the hall together for the first time that day, face to face across the table. And almost before I could set the stage for the conversation to follow, she rose out of her seat and pointed her finger at the man across the table who had been her supervisor and said, you can say what you want to your lawyers and to this mediator, but you and I are the only people in this room who knew what happened. And how you treated me on that day and the things you did to me were inappropriate. And you will know that forever. And I will know that forever, regardless of what we talk about today. And she went on for a while in a very emotional way and then sat down and the room was quiet. And that was the moment that unlocked the door to our next follow-up conversations, mostly in private, that allowed the case to settle because they had had that exchange. She felt better because of it. And from a legal standpoint, the other side had a feel for who this person was and how she would come across at the time of trial. So a technique of bringing people together in mediation is something that I use very often, because I often find in those momentary exchanges between the participants in the conflict, I learn more about what gave rise to that conflict than I would ever know from reading a lengthy mediation statement or listening to the lawyers, as important as that is. There are times in mediation where there's impasse moments and a party's having a hard time making a decision, and I'll use a technique that involves me drawing a circle on the board, maybe two, and maybe I'm in a private room with a woman who's been involved in a hostile work environment claim, and I'll say, look, this circle is designed to represent the criteria that you are thinking about in making this decision. And I've listened to you all day, and here are the things that I think are important to you. And I'll draw a slice of that circle and I'll label it. These are the facts. Obviously, the facts matter. This next slice of this circle pie, if you will, this pie chart, this is the law. And your lawyer and you have shared with me the strength of your legal position. But there's more to this decision for you, I gather. Some of it is emotion, and I'll draw a slice of the pie and label it emotion. And I'll talk about all the different things that I've heard over the course of the day that suggest that is important to her in making her decision. And then I'll draw another circle and I'll say, look, this is what your lawyer's thought process is, and it's different than yours. And that's okay, because you're all come here with your unique experiences and your unique criteria in making this decision. And what I'm trying to do is give this person the freedom to both understand why she's making the decision and why her decision is based on things different than maybe her lawyer, or in some instances, her expert who might be in the room would otherwise counsel her to decide. I will sometimes, as we get to that moment of impasse, I'll ask the parties to state the other side's position. And that seems a little strange at that stage of the process, but I'll say, I want to just pause for a moment and sort of visit where we are. And I've listened to you talk about your position all day. And I want you to state for a moment what you're hearing from the side down the hall and what you understand their position to be. And people will look at me kind of curiously, well, why are you doing that? And I'll say, no, please humor me, talk to me. I want to make sure you understand. And they will then proceed in their best way to try and articulate the other side's position. Well, I do that because we know from a neurological standpoint that it's impossible to hold two competing narratives in your mind simultaneously. And so for that minute or two or three that I'm forcing them in some way to articulate an alternate point of view, I'm helping them open their mind to a different reality. And that often helps as well in terms of at least schooling them that there's more than one way to view this conflict. And that's why we're still engaged in this back and forth negotiation. Oftentimes we talk about trying to expand the pie or come up with broader creative solutions to a conflict as a technique. And so, for example, it's not unusual for us to say in trying to get someone back into an employment setting who's been brought a claim for a hostile work environment, what if we were able to move you into sort of a different department altogether with a different supervisor? What if we were, if you have to be terminated, what if we were able not just to offer you money, but to offer you career counseling or maybe an interview with an affiliate company in the same type of career path that would enable you to get back on your feet in the employment context. The beauty of mediation, as you all know, is you're not limited by the four corners of the law. You're not limited based on the type of legal remedies that the court affords, but in mediation, particularly in the private commercial sector, one is able to expand the thinking to be as creative as possible. In fact, I define negotiation in my teaching of mediation as exploring the art of the possible. Exploring the art of the possible. So, and then of course you've listened to one of my dear friends, Peter Robinson from Pepperdine, talk to this group about apology and forgiveness, and what a treat that is. There is no better sort of thinker or person to sort of expand on those ideas than Peter. You're truly privileged to have heard from him. And so in the context of impasse techniques, don't overlook the possibility of apology and in all its forms. And while it sometimes is as simple as, I'm sorry, it can be more complex. And I'll give you one example. In an employment setting, I once had a situation where a woman had been unfairly accused of, through her computer, accessing a database within the company that she was not permitted to access. And the security team showed up at her desk one day with a box and told her to pack up all of the things from her desk. They walked her out to the parking lot to make sure she got in her car and exited the lot as her dismissal, embarrassing her in front of all of the colleagues that she had worked with for dozens of years. And we found ourselves in mediation trying to address that conflict, because it turned out through discovery that in fact she had not accessed that database. Someone had hacked her terminal and used it inappropriately to access the database. And so it wasn't enough that she would just get an apology from the company president as part of reinstatement. We decided what we would do on a given day would have the company president usher her back to her old desk in front of all of her colleagues and provide a public apology and statement, not just in writing, but an oral apology in front of all of her friends and colleagues on her first day back at the office. And in that fashion, we were able to kind of break the impasse that had stalled out over dollars that was not simply enough to restore her dignity in the moment. So I could go on. There are literally dozens of impasse breaking techniques. They all require knowledge in terms of when to be used, sometimes to be used in conjunction with each other, and they all require the same type of skill that a woodworker might demonstrate with a particular tool. But at the end of the day, as mediators, at the end of the day, any impasse moment requires patience and persistence. Patience and persistence. And patience and persistence against a backdrop of people being, if not exhausted, certainly tired, most likely beyond their pre-mediation positions, settlement-wise, where impasse is more likely to occur than not. And if your mediation mind is such that you anticipate this moment, you're respectful for people's efforts in getting to that moment, and you're skilled with the tools that can help get people beyond that moment, you're going to be best prepared to try and distinguish yourself as from the sort of excellent mediator that many of you are to the outstanding mediators that you may become still. So I'm reminded of the words of an 18th century poet in the United States who said that long after the final no, there lies a yes. And on that yes, the future world depends. And to me, that's a statement that reminds me of time and time again in this world of mediation, we're told no. But with patience and persistence and the knowledge that we've been talking about, there is an opportunity to get to yes. And in that opportunity, so much depends. So thank you for the opportunity to share some of these thoughts with you. It's been very kind to sort of pay attention. I'd love to open the floor, Fernando, to what is keen in people's mind and answer questions as best I'm able.
Thank you. Thank you so much, Bruce. I clearly see that your reputation precedes you. I would like you to know that we have 130 participants attending your lecture. It's a lot, believe me, please believe me. And several participants are praising your approach. So congratulations, Bruce.
Thank you. Thank you so much.
And now I'm going to the Portuguese channel in order to address the questions, okay?
Please.
So just a minute here. Desembargador Aramis, o senhor nos ouve?
Judge Aramis, can you hear me?
Sim, Fernando, eu tive que
Yes,
buscar.
yes, Fernando. I was running out of energy here, but I'm good now. So let me remind the participants that you can submit your questions using the chat box, okay? Or the Q&A box, okay? So Judge Aramis, the floor is yours. Well, first of all, I would like to thank Mr. Edwards for your lecture. It was excellent. Excellent talk, summing up many of the topics that we discussed throughout the course. So thank you for your time. Thank you for your your lecture.
Thank you.
I'm a little out of breath because I ran down the stairs to take my charger. I'm sorry, because I was running out of energy here. I had to take my charger. But anyway, Professor, in the beginning of your talk, you mentioned that your background in psychology. And I remember talking to one of my colleagues, Mr. Coelho, who also studied psychology back in his when he was young. And I've been married 35 years to a psychologist myself. So my question is, Professor Edwards, how important it is to have had this background in psychology for your role as a mediator, and how could we, I mean, for us as mediators, how could we draw from psychology, or how could psychology enrich our mediation programs, our mediation training programs? And once again, thank you for your availability and thank you for your talk.
Thank you. The pleasure again is mine. I don't think any of us need to be a psychologist to be an effective mediator. I do think it is very helpful to understand the human aspect of conflict. And that was my great fortune in studying psychology, being engaged in some counseling activities, as I also then developed my legal career, because it allowed me to bring together those disciplines in a way that gave me a vantage point from both perspectives. I think it's important at the broadest level to understand that as humans involved in conflict, we go through certain psychological stages. And again, not being a psychologist in the early days, I remember a course that I had taken in college it was called On Death and Dying. And that was the name of the book written by Elizabeth Kubner-Ross. And in those early days, she defined various stages of grieving that people had gone through after suffering traumatic loss, the death of a loved one, perhaps. And I thought about it in terms of conflict, that when someone starts in conflict, they're in a psychological stage of anger, of disbelief, of detachment. And over time, they go through a process of grieving, of disassociation, but ultimately the goal is to get them to a stage where, at least for those who are mentally healthy, are willing to let go of that conflict and move on with their lives. And I thought about that in the very early days of my career, when I wondered why it was that a case that had been going on for 5 years or 6 years or 7 years could resolve in a concentrated 7 or 8 hour day. And it dawned on me that what we were doing as mediators, we were paying attention to the human element of that conflict. We were listening to somebody in a way, for example, that our judicial system did not permit. You know, taking a deposition is not empathetic listening, for example. And what we were able to do as mediators, by bringing people, disputants, into the process and really truly listening to them in ways that require great skill, as one example, allows us to move them very quickly along that path toward resolution. And so one doesn't have to be a psychologist to be aware of that's what we're doing, and to develop the skills to assist us in moving people along that path. And it's such a powerful process that despite all of our collective experience and skills, I have to remind myself time and again, we need to pay attention to the process. We need to let the process work. And if we do it effectively, we can help people move psychologically along that continuum. That's the broadest possible answer to that question. There is a more specific answer to that question, Your Honor, as well. And that is that in the negotiation phase of the mediation process, one can school themselves in psychological techniques and understanding of how people negotiate and how people behave in negotiation. There's a lot that's written, and I won't take time now to sort of address issues of disassociation, of cognitive dissonance, of reactive devaluation, ideas that are based in psychology that impact mediation. Reactive devaluation, as an example, a psychological term, which simply says that people basically dismiss an idea based solely on where it comes from. And so if you have two parties sitting across the table and one side says, well, here's an idea, the other side may respond immediately, oh, that's a silly idea, or worse. Yet in many instances, we know that as mediators. So we might suggest to the other side privately, that's a great idea. Why don't you let me suggest it? Because it may come out a little bit differently if I do. And there are classic examples that both I and my colleagues talk about in teaching mediation, where out in the hallway, a lawyer has come up with a great idea and the mediator says, let me suggest it to the other side. And it proves successful because you've avoided that psychological issue of reactive devaluation. So at a more micro level, there's lots of things that by better understanding psychology, one can bring to the table to assist the parties. But first and foremost, it's a much broader understanding that both psychology and mediation respect and attend to the human element of conflict in ways that allow us to treat the individual as we look for ways to resolve the conflict.
Obrigado, Bruce. Eu vou...
Thank you, Bruce. Let Judge Dorothea and Judge Flavia, I would like to excuse myself and let me choose a question from the audience. And I would like to thank Simone and Amanda because there are several people in the chat complimenting you guys for the translation. There is a question by Kathleen Stamato, and she says, Professor Edwards, the mechanism of expanding the impasse, would you like this to be in a caucus session or in a joint session? I mean,
thank you. The impasse technique of trying to expand the pie, of expanding the conversation about possible solutions can take place either in private session or in a joint session. I think the advantages of engaging in that conversation in a private session is people feel, I think, more comfortable suggesting even some of the craziest ideas that come to mind without regard to how they might be reacted to in the first instance by others. Certainly, lawyers will come up with ideas in the private session without having asked their clients for permission, something they would probably never do in front of the other side. So one of the benefits of using the private session is it allows more for an unfettered conversation and perhaps a more creative conversation around expanding the pie concepts. So, but it can be done in joint session as well. And one of the benefits of this technique and one of the freeing aspects of understanding this technique exists. As mediators, we so often come to the mediation thinking we have so much to do, we have so much on our plate. We feel oftentimes responsible for the outcome. But this is a way of shifting responsibility, of opening the door to input from parties to basically say, I, the mediator, don't have the answer necessarily. I can help you with the process, but please substantively share with me your thoughts and ideas. Take responsibility for what meets your interests and needs and your client's interests and needs, and really fan the flames of conversation and creativity to engage them. And when you do, I think on balance, the best practice may be to start that exercise in private, but don't overlook perhaps the possibility of bringing people together and saying, I'm out of ideas. I think it's time for you all to be more engaged. Let's talk collectively about what might help resolve this. And that too has its own value.
Muito obrigado, Bruce. Agora eu passo a palavra à desembargadora.
Thank you, Bruce. Now, Judge Flavia, do you have any questions, please? Professor, congratulations. That was an excellent talk. You brought many interesting topics for me to think about. Thank you very much. But one of the things that concerns me in our mediation process, especially in our reconciliation centers, is the time that we have between sessions, from one session to the next. It's a short amount of time. Oftentimes, it's not possible to apply all the tools, all the techniques available. So when we have a short amount of time between sessions, what would you tell us? What tricks could we use to advance, let's say? Because when we have time, and it must be so good, to do, is to take time in a long session to make things happen. But it's not often the case here. So what could it tell us to help us in this case? Thank you. Thank you again.
Thank you for the question. The question you pose is literally what has kept me awake at night the last several days, thinking about how to try and answer that very question, because it illustrates the tension between the form and the substance. It illustrates the tension between the process that constrains you and the techniques that I so often try and teach people that are at odds. Now, does that mean you can't use these techniques? Of course not. You can, but you have to do it with an understanding and appreciation for the structural limitations that are around you. So to answer your question directly, you can listen to people clearly for a period of time, but you might have to say things like, unfortunately, we have some limited time. And while I would like to listen to you more, I'm here today to try and assist you in exploring possible ways to solve this. So I have to make decisions about how much I can listen to you versus how much time I want to spend helping you in a negotiation process. Do you understand that? And really be honest with people about your functional limitations in the process that at once respects your opportunity to listen to them and devote as much time as you can without jeopardizing the ability to move on and help them. And in the words that I just demonstrated, what I'm trying to do is further my connection with them, be honest with them and credible, and explain to them how the use of time needs to be segmented in ways that are designed to meet their needs, not yours. Okay. Hopefully that helps a bit, but I don't want to just gloss over it. To me, it may be that after some months or years of experience with your process, and I know from teaching judges around the world, there are very real limitations, but does that mean you expand your program to include panels of attorney mediators that might have more time to assist, or could lighten the caseload of mediation so you could spend even more time on a particular case? Or in certain venues, there are certain judges that are devoted exclusively to negotiation with parties, so their caseload allows them more time to mediate. I would encourage you to expand your thinking beyond simply the four corners of that question, because there are opportunities out there. And in your effort to develop a culture of mediation, one of my concerns is over time, the success of implementing a culture of mediation will turn on individual experiences, day-to-day experiences in the mediation process. And again, going back to my satisfaction triangle, if people go through that process, however you construct it, so they come out feeling that they've had process satisfaction, that they've had psychological satisfaction, and this is important, even if they don't have outcome satisfaction, even if they have not resolved their case. But if the other two legs of the triangle are satisfied, we know by studies that they will say good things about the process, that they will return in that particular instance to another day of dialogue, or in the face of another conflict, they'll choose the mediation process. So it's incumbent on all of us to think about the process that we're delivering as it relates to that process satisfaction. So don't, and I say this carefully because I would never disrespect the limitations that are imposed on people, but don't overlook the opportunity to expand your thinking with these lessons in mind about how to best implement this process. You're welcome.
Obrigado, Bruce. Temos uma pergunta agora.
Thank you, Bruce. We have a question by Luciano Coelho, our dear friend. Luciano Coelho was mentioned by Judge Aramis. Dr. Coelho, Judge Coelho, sorry, he's got a degree in psychology and also he's a judge. He says that emotions are the key. How do you see the necessity of the media? How do you see the need of the mediator to know their own emotions, to steer their own mediation process?
Another great question. The very first thing that we as mediators need to do once we appreciate the important role, the critical role of emotions in our lives is self-reflection. And in that process of self-reflection, I mean specifically to get comfortable with who we are around emotions. And there are various techniques for doing that. In one of my mediation courses online, I have a technique where I ask people to think back to their earliest days of childhood and the closest relationships they can identify, whether it's siblings or parents or grandparents who lived with them, and to then sort of draw lines to represent those connections, and then to put some descriptive value based on the emotional attachment or how people dealt with emotions in those relationships as one tool for really thinking about how we came to develop our comfort level around dealing with emotions. And then to sort of extend that thinking to the present day and ask yourself critically, how do I deal with emotions with my spouse? How do I deal with emotions within our family? Do we come from a culture where people can yell and scream at each other over a disagreement and then, hours later sit down at a family meal and put it behind them because while there's quick flashes of emotion, we're able to get beyond it? Or does that emotion sort of linger in the background and people don't talk to each other for hours or sometimes days because they don't want to surface those emotions? All of this is helpful as individuals because our ability to help others in conflict, particularly in environments of high emotion, start with us being able to understand and appreciate our emotional competency. And what I mean by that is this: early days of mediation for many, and 80% of my partners are retired judges. And so they come from an environment in the courtroom where it's more about the facts and the law than it is about emotion. And they come into the mediation setting, and when parties start yelling at each other in a joint session, their default setting is to quickly adjourn the joint session and move people into private conferences. And yet, as mediators, I, at least for one, know that in those moments of emotion, not only are people venting as they need to do, but as I've said already, they're also giving me a deep snapshot look into what lies at the heart of that conflict. And so I have trained myself to be comfortable in the face of strong emotions, to the point where sometimes lawyers will look at me in a joint session as their clients are saying things in a heated moment of emotion, and you can just read the lawyers' faces. Are you going to let this go on? This is uncomfortable for me, the lawyer. Shouldn't we break up and move in different settings? And I sit, and sometimes I'll say to the parties, I'm content to let this go on as long as you are. If you think this is productive, I'll sit back and listen, because if it's good for you and helpful, I think it's a valuable use of our time. And at some point, if it extends beyond that, I might suggest again, maybe it's time for us to now separate, but this has been helpful for my understanding. Hopefully it's been helpful for you to share your feelings. But in that fashion, as mediators, we're both becoming more comfortable with who we are and developing our emotional muscle. I'm reminded of one day when I was in a conference room mediation in JAMS in San Francisco, and there was loud yelling in the room behind us, and the volume rose and rose and rose to the point where I was starting to become a little concerned about what maybe was going on in this different mediation behind me. And I stuck my head out in the hallway, and as did a couple other mediators. And a few minutes later, the mediator walked out of that room, and he happens to be a retired Supreme Court Justice of California, who is Italian American by culture. And he saw all the mediators kind of looking at him, and he realized that we'd been overhearing this dispute going on in his room. He said, no, nothing to worry about, just a couple Italian brothers sharing their feelings. And he turned and walked back into the room. And he was obviously very comfortable in that moment with a sort of cultural normality of emotions at play. And again, a good example of what we as mediators need to open our minds and ourselves to as we develop our emotional competency. Thank you for that question.
Thank you, Bruce. Now, Dorothea, it's your turn.
Thank you, Professor Edwards, for your great lecture, very instructive. And actually, my question has to do with Judge Flavia's question. And I think we were kind of connected, Judge Flavia, because my question is very similar to yours. But what I would like to know, Professor Edwards, is that when parties are in impasse, in given that short time we have for the court-connected mediation, do you believe it is productive or useful to reschedule another session for the specific question, a point of impasse? Thank you.
Thank you. Yes, I would not overlook the impasse breaking technique of time, of allowing parties to move along that psychological journey in different sessions. I think it is sometimes unrealistic to expect that people who have spent months, if not years, in conflict, that within hours can move to a moment of letting go of that conflict. And to some extent, that question brings to mind the process design of family law mediation. Family law mediation in the United States is typically structured as a series of separated but sequential mediation sessions, maybe every Monday night for 2 hours for a period of weeks or perhaps a month. The parties will get together and talk while they can focus, while they can be comfortable in the process, but then need some intervals, need some time in between mediations to think about, reflect on, contemplate, and adjust to whatever is being discussed. And so, particularly in an environment like yours where there is limited time, I think it is critical to consider the possible benefits of separating some of those sessions by time to allow people to come to terms with what you're proposing.
Thank you.
Thank you.
Bruce, eu sei que você tem uma mediação por iniciar.
Bruce, I know that you have a mediation session about to start. How long do you still have? Let me know.
I am fine. I don't start my mediation for half an hour.
Okay, thank you. Thank you so much. Nós temos uma pergunta, então, do...
Oh, thank you. We have a question by Dr. Rogério Neiva, one of the main names in labor law mediation. So how can we work as with a repeated player, with a person who disrespects legislation, to who looks for doubtful rights? What the possibility of mediation in this case, and what is the best course of action for a person who repeatedly looks for mediation for doubtful rights? I don't know if I translated that correctly.
I'm sure your translation is excellent, but I am having a difficult time understanding the question. Let me answer it this way, and if I don't, please ask your listener to follow up. It is not uncommon as mediation evolves, particularly in the earlier stages, for lawyers particularly to doubt its applicability in their world, its potential for success. Even at times, it might be viewed to be at odds with their perceived role. And so, for example, over the years, we've developed a course in mediation advocacy for lawyers, because so often, not always, but so often, lawyers as a major stakeholder group in the mediation process resist the process. And the question is sort of, why do they resist it? There's some classic examples. When the Supreme Court of Italy tried to impose mediation on lawyers about 12 years ago, lawyers went on strike for almost a year, and to the point where the Supreme Court retracted the law, the legislation favoring mediation, and really set the development of mediation back many years in Italy. Similar thing happened in India 20 years ago, to the point, literally, I shouldn't laugh, because we always think about lawyers as being so conservative and respectful, yet lawyers actually rioted in India when they were forced to go to mediation. And in both those instances, in India and in Italy, they were not included in the development of the law. And so as major stakeholders, by definition, they felt initially left out of the process. And what I found trying to help implement mediation in different cultures around the world is the sooner we can bring lawyers into the process, not just in helping formulate the policy or the legislation, but the more we can help them understand how they can proactively participate in mediation, understanding the process, and knowing how to deliver successful results for their clients, the further we will advance the mediation culture. And so many instances I address lawyers, I say, as lawyers, this is a fear-based concern in many cultures, fear in giving up control. As lawyers, we're likely to be in control. We're certainly most comfortable controlling our clients and their participation throughout this process, being the guardians of the gate, if you will, to their participation. And ultimately, there's, in many instances, financial incentives for lawyers to continue in the litigation process. And I respect that. And there's a whole different conversation to be had in many cultures about how lawyers are appropriately compensated in ways that will promote mediation. I'll give you one example. In the very early days of mediation, one of the target groups for us going to sell the concept of mediation were those plaintiffs' lawyers who had contracts with their clients called contingency fees, meaning that they were not paid by the hour, but they were paid by the result. And they were only paid when the case resolved. And I would go to these lawyers and say, what if I could share with you a process that would not only deliver winning results for your clients, meaning making them happy about their participation in this process with the outcome, but also advance the day that your firm could be paid, sometimes by a matter of years. What would you say if I could talk to you about that kind of a process? And they would say, tell me more. And those were some of the early fans of mediation, early consumers of mediation, because it met their needs. So to answer that question more specifically, I would probably need to know a bit more, but don't overlook the importance of understanding the why, because as a psychotherapist who I teach with in Europe tells me, once you understand the why, the how will follow. So understand the why there is that resistance. Do they have lack of confidence in the process? Do they worry about the lack of client control in the process? Do they have concerns about how to navigate that process successfully because it's new or different? I mean, these are the things I would be asking to better understand how to try and address that concern, just as you do in any mediation. You start by understanding the interests and needs, and then you try and fashion solutions based on those interests. Hopefully that gets to the question. I apologize if I've missed the target slightly.
Obrigado, Bruce. Respondeu sim.
Yes, Bruce. Yes, you did. Thank you very much. We have more questions. We have several questions. We have a question by Mauricio Mazur. Which are the what a mediator can do that is inappropriate in a situation of an impasse? What a mediator should not do in a situation of an impasse?
Excuse me. First of all, as mediators, we always want to ascribe to and follow the highest ethical standards. And at Pepperdine University, I've taught courses on ethics in mediation. And while we haven't discussed that today, the question at least promotes us touching on that subject. As mediators in impasse moments, sometimes there is a tendency to look past those types of ethics or limiting moments on our behavior. So what do I mean by that? While many mediators may scrupulously attend to confidentiality throughout the mediation process, as one gets toward moments of impasse, there might be a temptation to be less constrained by the confidential information we've heard. And sometimes mediators will relay information inadvertently. A classic example of that is I may have an impasse that requires the parties to leave the room and to leave the mediation that day unsuccessful. And the next day, a lawyer might call me up and say, you know, I was leaving the building last night with the other lawyer and he told me he told you such and such. And the temptation is, because there's an impasse, the temptation for me would be to say, well, that's not really what he told me. He shaded that in his conversation with you to look more favorable, and for me to start to reveal private conversations I had with that lawyer. But I have to catch myself in the moment and say, I'm still mediating this case. I don't have permission from that other side to share confidential communications. And so as an example, in impasse moments, I have to be even more careful to be ethical in the moment. Another example of what I call moments where one gets close to the third rail and faces the potential for electrocution, in my metaphor, is when one comes on too strongly with their evaluative position. Because keep in mind, as mediators, particularly in evaluative moments, you have maybe one opportunity to shoot the arrow, to offer your opinion, to try and persuade somebody through the value of you being a judge. And so it's very important that you pick the right moment to use that weight of your authority to express your opinions. And so it's not so much a question of being wrong, it's a question of the wrong timing. And in mediation, many of you have heard the expression, the right answer at the wrong time is still the wrong answer. The right answer at the wrong time is still the wrong answer. So be thoughtful in that impasse moment. The technique or tool that you're using, is it the right answer in the right moment, or is it still the wrong time? And should you keep that tool in your toolbox for the time being and look for a more opportune moment to make use of it? But the question is good in that it suggests truthfully that many missteps by mediators occur in those difficult moments of impasse. And those moments of high emotion Those moments where clients might sometimes yell at me as the mediator or raise their voice or act in ways they're not proud of later often occur in impasse moments. And I have to respect that. And I often tell people, you don't have to worry. I sign up to put myself in this position. I appreciate the fact you're here and working hard, and your raised voice, I know, is not personal. It's a reflection of your frustration for the moment you're in. Let's take a deep breath. Maybe you want to take a walk for a couple minutes, and then let's come back and let's focus on what we can do to move this discussion forward.
Obrigado, professor. Temos uma pergunta agora do Lauro de Campos, servidor.
Thank you, Professor. We have a question from Lauro de Campos. And the question is, Lauro, let me try to adapt your question. What are the main tools used in the mediation and conciliation? You know, the North American types that can inspire its uses in Brazil. And Professor Bruce Edwards, I'd like also to ask you to speak about caucus, and because some judges in Brazil don't like to use the caucus method. So can you please, you know, talk about that a little bit?
Okay. So the first question first, I think one of the inspirational things that I hope I can deliver coming out of today's conversation is this process works. It is a tremendously successful process. That's not news to anybody in this conference, but it is an important starting point for conversation. In the United States, we have a 250-year-old legal tradition. 400 years if you go back to our roots in the Commonwealth of England. And yet, in the last 30 years, we have fundamentally changed the culture of our court system so that mediation is now a required approach to conflict resolution in a multi-door environment. Before parties get scarce judicial resources, they must go through a mediation process. Mediation is now finding its way into many contracts, not just business-to-business contracts, but consumer contracts between banks and customers, doctors and patients. Certainly, as a stair-step approach in construction agreements, parties are required to go through mediation before arbitration or litigation. I could go on, but in 30 years, the culture of mediation has rapidly developed in the United States, and in different parts of the world, it's developing even more quickly. We teach in Rwanda. I've been going there for the last 4 years. Our courses have now included the Chief Justices of the Supreme Court. Our current course has the Minister of Justice and Ministers of Labor and Finance. And just last week, the President of Rwanda expressed a statement favoring a policy of mediation at all levels of government. And that's all transpired in the last 4 or 5 years. My point is, I could go on with different examples, but mediation has taken root and shown itself to be an extremely successful process. And that should inspire us all to look for ways to implement it in appropriate ways in appropriate sectors of society. I mean, I appreciate we're now talking about labor courts and a more narrow segment of the judiciary, but much of my message goes beyond the judiciary to all parts of government. And I have nowhere closer to look than our own sort of challenging government in the United States, where we're trying to work with government leaders to develop these same mediation skills in use of legislation. How can we promote civil discourse? How can we promote conflict resolution skills for those governmental leaders who have there are tremendous consequences to the decisions they make, just as in your country. And if we can somehow school them in techniques to make them more efficient and more dispute resolution oriented, we are all going to benefit. To the second part of your question on caucusing or private meetings, it all starts by understanding what the client's interest is, at least in the private sector, because there are many days, as the questioner suggests, in cases where the parties want to be together and need to be together. and should be together. And so I've done some work in the area of trusts and estates, where the second generation of family members are questioning how their parents' Silicon Valley business is going to be passed on to the next generation. And the structure of that mediation is designed to keep all these children together in the room to discuss simultaneously what that next generation's ownership and governance of that business is going to look like. And I can't imagine the process where I would run from one room to another room to another room in a seemingly endless loop, trying to do that same exercise with 5 or 6 second generation adult children. So again, it starts with caucusing. Caucusing has benefits. There are those people who view it as having detriments. And so I don't think it's fair to say there is one right answer. I think the only wrong answer is the answer that's not well conceived, the answer that's not thoughtful, the answer that is not applied to the needs and interests of the parties. Because if you start there in designing the right process, you won't go wrong. Now, you also need to remain flexible so that in the middle of the process, if things aren't working, you have the wisdom and the knowledge and the skills to suggest to parties, you know, this process we designed, it just doesn't seem to be getting us where we need it to be. How about if we try something different? And I've certainly had those days where parties have wanted to start in private caucus, and I have worn out the carpet running up and down the floor, exchanging positions. And somewhere late in the afternoon, and we've made little progress, I say to people, you know, to me, this doesn't seem to be working. How about for you? Might I suggest we come together in a joint session and have a face-to-face conversation? I've already suggested that as an impasse breaking technique. And in many instances, when you do that, it sets a whole different course. It creates a whole new tone to the conversation that allows you to move the discussions forward. So don't be too judgmental about a particular process design or a particular approach to mediation. The best mediators understand that there are multiple different approaches, and they know, like any other tool, how to and when to suggest them, and when they're not working, to reach for another option or another tool.
Thank you, Bruce. Our time is running out, so let me make you the last question, okay? So you said the limits of my words are the limits of my world. This phrase makes me think about bias, and here in Brazil, we don't approach bias as we should address this relevant mediation subject. So I ask you, how to deal with bias in impasse, especially with overconfidence and confirmation bias?
In asking the question, you're beginning to answer it, meaning understanding the why leads you to the how, leads you to the answer to the question. We could have an entirely different conversation on another day about the question of bias. Certainly one of the major developments in the world of mediation in the last 5 or 10 years is a better understanding and appreciation of how bias affects us all. I don't know the translated word of bias in Portuguese. In English, the word bias has a negative connotation, which is too bad. It's almost unfair. Bias really refers to how our human brain processes information. And one of the things we've learned in the last 5 or 10 years is how this idea of implicit bias affects our ability to process information in the world and environment around us. The example is that because of the way our brains are structured, we process thousands of data points of information in each moment we exist. The vast majority of that input is processed at a subconscious level, meaning without our conscious awareness. Otherwise, we'd be overwhelmed with information. We couldn't possibly sort through all of that at a conscious level. And the consequence of that is that many of the decisions that we make are based on limited information. And so to answer the question more directly, understanding and appreciating how our minds work and the impact of bias at a subconscious level allows us to surface this conversation, to even talk about it with people. This is what we do when we go out to police departments and we teach them on implicit bias. And we say, when you get out of your patrol car and you approach somebody in a car, your mind is processing 1,000 bits of information in that moment, much of which is related to self-protection, but some of which is also related to trying to quickly judge who that person is that's in front of you. And so when you're in a negotiation context, helping people appreciate how bias may be impacting their decisions and their perception of people down the hall is a large part of what we do. And I'll spend hours, many a day, saying, I've listened to you. I appreciate your perspective on how this evolved. It's important for me, though, to share with you what I'm hearing from others down the hallway. And that's my effort to help overcome that implicit bias. Because as individuals, the antidote to implicit bias is curiosity. It's developing the real data points, the hundreds of data points that really more carefully and accurately shape the perception of what's in front of you, as opposed to those selected data points on which you're basing your evaluation. And whether you help that person come to that realization themselves or they do it on their own, it's important that you address that head on. So I hope I'm not doing an injustice to a very important topic. And perhaps, Fernando, that's a very good segue for you in a different conversation to really tackle a very important topic in the world of mediation.
Yes, it is. So thank you, Professor Bruce. My apologies to Maria Cláudia and José Marcos, because we don't have time for your questions. And Professor Bruce, be sure that we absolutely took advantage of your knowledge and your experience. And you also have inspired our audience. We have so many comments, so many thoughts here that I would like you to learn more from the chat, okay? So thank you so much. I would like to hear your words now, and later I will come back to have our guests to close this event. Okay, Bruce, so please, your final greetings.
Thank you again for the opportunity. I'm humbled by the chance to really share my thoughts and experience. I hope you will look at these ideas through the lens of what's important in your environment, but also with an idea sort to expanding your thinking about what could be possible. I remind everybody we are all in this together, and our common goal is to develop a culture in mediation that crosses cultures, that crosses boundaries. Because while we're focused in a somewhat narrow environment today in our discussion about labor law and the courts, our existential challenges that we face around the world are only going to be addressed successfully by our abilities to sort of dialogue and listen to each other and truly apply these same kind of techniques, not just in our professional and personal worlds, but in our broader vision of how we interact as human beings. And I hope this is just the first of many opportunities to stay in touch with all of you. Feel free to join me on our online academy. If you have questions, I'll do my best to answer them. But otherwise, when the pandemic does clear, I hope one of my next stops will be again to visit friends in Brazil, and I'll have the chance to meet many of you in person.
We would like to have you here for sure. And now I would like to hear from Judge Aramis, your final greetings.
Obrigado, Professor Bruce Edwards.
Thank you, Professor Bruce Edwards, for your participation. You're closing beautifully this course on mediation of the 9th region. And it's a mark. We are starting the conciliation week, which is starting next Monday all over Brazil. It's the National Week for Conciliation and Execution. We have this Brazilian week starting Monday, and this really marks the beginning in a great way in the labor law segment. So thank you so much, Professor Edwards. We're looking forward to receiving you in Brazil in the next opportunity.
Thank you.
Dr. Flávia Falcão. Professor, it was such a privilege to hear your thoughts. I'm sure they will help us so much in this mission of spreading the new culture, this peaceful culture in the labor justice. And I'd like to thank the 9th Judicial School. Thank you, Professor Edwards. Have a great weekend. Thanks for being with us today.
Thank you.
And Dorothea, my friend.
I also thank you for the great, I repeat, the great lecture. And I would like to welcome you again, right, Fernando? Soon, right? If not personally, at least virtually, but personally even better, right? And have an excellent, a happy Friday, okay? And thank you very much for your thought, and thank you very much for your words.
Thank you so much. I look forward to meeting as well.
Então é isso, meus caros, professor.
So, my dear friends, on behalf of the Judicial School of the 9th Region, it was such a pleasure having you here. We have been trying to take mediation to the next level. I mean, to be excellent with great quality. And we have no doubt that your lecture brought many reflections. Is going to make us think around the weekend, all over the weekend, you know, about this. I mean, really, I thank you for your presence. You being so available, so willing. And I think that not only you, but your wife, Susan, who helped us, you know, with the connection. Thank you for the members of this round table, Judge Aramis, Judge Flavia, Judge Dorothea, the interpreters Simone and Amanda for their spectacular work. Thank you so much. On behalf of the 9th School, thanks for the attendees, for the Zoom technicians, and so on, and from the YouTube guys too, you know, the ones that are making this happen through the streaming and so on. Thanks for the students. And now I'd like to end this action, this event. Happy Friday, as you say in California, right? In Brazil we say Fridays, meaning, whoa, thank God it's Friday or something like that. All right.
All right.
Bye.
Thank you, everyone.